we go. Hello, this is the Ninjutsu podcast. I'm your host, Don Rowley. With me is a friend, and I will let him introduce himself and explain why you should listen to him in this podcast about the legal realities of self-defense. Take it away.
Thank you, Don. My name is Alain Burrese. Don and I have known each other for decades now, and part of why he asked me on here is I have military background. I was in the 82nd Airborne Division and the 2nd ID, where I was a scout sniper with them way back in the 80s. I've been a martial artist since the 80s. In the 90s, I really started focusing on Hapkido and have pretty much been with Hapkido ever since then, still training, still teaching. Also have a business degree, communications degree, and a law degree. And while I'm not practicing law currently, I used to play lawyer, including a while in the Missoula prosecution office. So I was with the Missoula attorney's office and prosecuted. And we'll talk about one of the cases that's relevant to today's topic here in a little bit. But got martial art background, legal background, and we're going to talk about some of that today.
Right. So this is kind of, I have other podcasts ready to go, but the Daniel Pena case is basically in the news right now. Of course, somebody might be accessing this years from now and it's forgotten, but essentially a former Marine, and, I won't hold it against the crayon eaters, but he was riding on the subway and there was this other guy, and he was black. Well, I guess it's appropriate to say was now, but he acting extremely erratically. One of the witnesses, again, also black, looked like a elderly grandmother, said that she had been riding the subway for decades, and until that day, she had never felt like she was going to die until he started accosting her and everyone else on the train. Penny tried to, with at least one other guy who was black, attempted to, control and hold down the guy, and it ended up after the police came that the guy died. And there's a few things like the coroner called, even though there was drugs in the system, the coroner called the it homicide before the toxicology reports. There's a lot of things. So they're going for manslaughter. That was just thrown out. Now they're going for negligent homicide. The reason why the manslaughter case was thrown out is because, again, it was a hung jury. I'll try to link to Nate, the lawyer, who really goes into this case for what we know now. But he was basically saying, this should have been a slam dunk for the defense. But obviously there was at least one person that was saying, no, guilty, guilty, guilty. And of course, there's a lot of politics involved. I mean, the Black Lives Matter chapter there was really screaming. I mean, I saw something this morning about them screaming about, since the manslaughter charge was dropped, how our system is geared for murdering black men. And well, we'll get into that. But before we get into the case, we're probably going to wait for the final verdict to come in. This time around, I really want Alan to explain some of the things that martial artists should know, because a mutual friend of ours, we call him Eaglemon, put it perfectly when he said that teaching martial arts and self-defense without teaching the law of self-defense is like teaching how to drive a car without teaching them what stop signs and such are. So first of all, Alan, what do you think of the term better to be judged by 12 than carried by 6?
On the face of it, yes, obviously you would want to be alive is better than being dead, but people flippantly throw that out there too, and it's like, well, I don't want either, really, especially when you know the legal system. So, I mean, I think, if you look at just the core, would you rather be alive or dead? Of course you want to be alive. But to flippantly throw that out there because I'm carrying a gun or doing this and I'm a big macho guy and just going to kill whoever, that's stupid, because I don't want to be spending my life in prison either, which might even be worse than being dead in certain
Yeah,
cases.
yeah. I mean, I know that I'm just too cute for prison. Now, here's a question for you. Have you ever run across someone that said that it actually had to face the legal system?
I don't think so.
Yeah, I don't think anyone that's actually had to be, like looking at life in prison has ever said anything like that. But I know plenty of people that will drive through the worst part of town with an illegal knife rather than take 5 minutes to go around and say better, it's like a
Right.
justification for stupid acts.
Right.
You know, if you're a woman who is being stalked by a boyfriend and you cannot buy a gun because of a waiting period or something like that, and you pick up a gun, from a friend illegally because, he showed up last night on your front porch, maybe,
Yeah.
but doing stupid stuff anyways.
Right.
Now, could you explain like how self-defense is like a proactive rather than a you got to prove self-defense rather than.
Right. What we call that in a legal term is an affirmative defense. So if I'm being charged with a crime of hurting or killing someone, and I say it was self-defense, the affirmative defense, I'm admitting, yes, I did. I killed them, I hurt them, but I had a justification. And then it puts the onus on me. I have to prove that justification. Where on the other side, if they're charging me and I just say, no, I didn't do anything, and you're not claiming self-defense, they have to prove the elements of the crime. When you plead self-defense, it's an affirmative defense. You're saying, yeah, I'll give it to you. I did what you saying I did, but I was justified in doing it. And you have to prove that justification.
And how many times, in your experience and, talking with the others, your personal experience, such, is it a case of somebody not doing self-defense, claiming self-defense, or, well, two different cases. One, they honestly knew that, they were in the bad. They they started it. They could have, they know that they're in the wrong, but they're claiming self-defense, criminal, such like that. Two, how many people do you know think that they were doing self-defense, but it really was a dick wagging contest at 2 o'clock in the bar, 2 a.m. in
I
the
think,
bar.
I mean, that happens a lot. And I think before we get too far into that, let's make sure we get a couple terms right. Because you mentioned murder and manslaughter and now negligent homicide, what's going on in the case. Some people don't even know what that stuff means. Now,
Right.
the real classic one is manslaughter in many jurisdictions has an intent to it. Murder has an intent to it. Involuntary manslaughter, which is also called negligent homicide, doesn't have the intent. Now, the difference is the classic example, you're sleeping with my wife. I come home. I had no intent to kill anybody when I walked in that door. I catch the two of you. I kill you both. That can be voluntary manslaughter or a manslaughter because of that rage state I was in. But I still intended to kill you in that rage state. So it's a manslaughter versus a murder. If I caught you or I heard that you guys were sleeping together, and now I plan out over the next month or two how I'm going to kill you both, that's murder because I got that intent and I'm planning it.
Okay.
The,
And just to interject,
yep,
homicide means someone killed someone else. Could be accidental, could be,
yep.
could be an accident. Murder is a legal term for they
They planned
intended
it
it to.
intent, and it has that intent element. Where the
Okay.
manslaughter in certain jurisdictions, voluntary manslaughter has an intent element, but it's different. It can either be in that heat of the moment, has to be in the heat of the moment, or it can also sometimes be a lower manslaughter where I intended to hurt you bad, to teach you a lesson, but I killed you. And so that can be a manslaughter. Then involuntary manslaughter is sort of the same as negligent homicide. That's where I didn't intend to kill you. That's Elvis Presley, Jailhouse Rock, punched the guy fell, hit his head, died. Elvis went to prison for manslaughter, involuntary manslaughter. And sadly, in real life, you don't become a rock star when you're in prison like Elvis
Right.
did.
Yeah.
So those
So
terms are important in the Perry case because they're saying they couldn't prove the manslaughter. There was no intent. Now they're trying to go for the negligent homicide, which is saying he was reckless in what he did, even though he didn't intend to kill him. What he did caused the death. So it's a lower level of both punishment and lower to prove, because you
right.
don't have to prove the intent that you had to prove with the New York's manslaughter.
So basically, involuntary manslaughter is you messed up big time. Like you modified the safety on your pistol and it went off and it shot someone. That could be involuntary manslaughter. There's no
Yep.
intent. It just you did something you should not have done, fool with the safety.
Yep.
Or, like one case here in Colorado Springs that homicide hunter had, a landlord decided to save some money, uh, worked on the heating system himself, forged the paperwork instead of being out. A family of 5 died of carbon dioxide poisoning. That
Yep.
would be involved. He did not intend to do, but he
Yep.
forged the signature of someone who was an actual contractor. He did
Yep.
the work himself instead of getting someone that he did not intend to kill them, but it wasn't a pure accident. It was something he did.
He did. Yep. And
Okay,
that's, the
so
Elvis Presley punching somebody, they fall down, hit their head. That can be an involuntary manslaughter. Never intended to kill him. I just was going to teach him a lesson, punch him or whatever. And that can happen. So that's, what they'll try now. No intent is necessary now. They will try to convict him on that if he put the chokehold on, knowing that it could cause damage, but it was negligent that he put it on and that caused the death. So it's less to prove, and it'll be a lesser sentence if he's convicted of it.
well, it's up to 4 years. What if he thought that there was nothing else, or he knew nothing else to do? I mean, again, trained martial artists have more tools in their toolbox.
And,
He was, from the looks of things, he was just trying to keep the guy from getting back up.
and that's the problem with juries. You don't know what you're going to get. I mean, the old joke is, do you really want 12 people that weren't smart enough to get out of jury duty to be making decisions? There's some truth in that because while it's supposed to be someone of your peers, not everybody, you and I on a jury, we got military, martial art, and experience with real violence. Most people, their experience with any of those is watching TV. Chuck Norris could kick the gun out of a guy's hand. The Lone Ranger could shoot the gun out of a guy's hand. And they don't really know what, we both know martial artists that could handle themselves very well in the street. We also know martial artists that couldn't fight the way out of a paper bag. The public doesn't know the difference. The public doesn't know real violence versus what's on TV. And so you and I on a jury, friends of ours that are in the same professions on a jury, completely different dynamic than 12 people that have never experienced violence or martial arts and so forth. So
Reality.
we're dealing with that too, because their perception of it is, well, if Chuck Norris could have done it, why couldn't this guy have done it?
Yeah. So that's that. So could you explain things like when, this is the thing is, one thing I would like you to address. Do you have to wait until someone actually attacks you to take action?
No. If and again, we get to this reasonable belief, and that reasonable standard is always debatable too. But if you believe someone is going to hurt you or someone else, because we have a right to protect another person, just like we have a right to protect ourselves, you don't have to wait for them to get hurt or for you to get hurt to intercede. Now, you're allowed to use the force that is going to be used. So if you and I are the same size, I can't pull out a gun if you are empty-handed. Although now I know that you've trained in the martial arts for many years. Maybe I haven't. I mean, there's disparity of force in a lot of different ways. But on the face of it, we're allowed to use the force equal or less than what that person is using to hurt us. We're not allowed to kill someone unless we have a reasonable belief that we will be seriously injured or killed ourselves if we don't.
Okay. So in other words, no lethal weapons in an unarmed fight.
Unless
Yes.
there's a really disparity of force. I mean, if you had 100-pound woman that's going to be beat up by a 300-pound Goliath is going to beat her and rape her, she would be justified using a weapon more so than you got two guys the same size and the guy's coming at you with fists. I mean, a guy my size coming at me with empty hands, no weapons at all, and I pull a gun, I'm going to get in trouble. You
Right.
know,
So just pulling the gun. Now, what's that called in, pulling a weapon? What's that called in legal terms?
brandishing, which
So,
is illegal. I mean, you should never pull a weapon unless you're ready to use it, and you better be justified. And again, I
Um,
wouldn't be justified a guy coming at me with empty hands being stupid, just, so there's a whole bunch of stuff that goes in here, and it gets into what would a reasonable person believe at that time.
and also one thing, Rory Miller, he calls them articulation wars. So again, as you said, as an affirmative defense, you have to describe why you took the action you did and concrete things. I mean, it's not just, well, I could tell he was going to, you know, that, I mean, I knew that he was going to pull a gun. Well, why? I mean, because he told me he had a gun and he reached into his pocket saying, now you die. Okay, well, if he's, and they find a gun, or the guy's hand is still in the pocket trying to convince you, when they roll up. But it is an affirmative defense.
And you do have to
And
and you have to articulate why you did what you did. And for an assault to happen, there needs to be on that the person that's attacking you or attacking someone else, they have to have the intent, they have to have the opportunity and the ability. And
so,
so,
so
how do you
like,
infer intent? It's their
right.
actions. What are they doing? But are they capable of it? I mean, it's one thing if a man is coming at you with his fist. It's like, okay, he looks like he could probably hurt me. What if a little kid is coming at you or
Oh,
a
yeah.
really elderly person? If they don't have the ability, you know,
Yeah. I mean, toddlers are homicidal little sons of bitches. When they are having a tantrum, it's like if they actually had the ability, yeah, they would probably lay waste half the city, but they do not have the ability.
and they have to have the
Unless
opportunity,
and the opportunity. And
which,
if they're across the street, if they're across the street and saying that they're going to beat you to death on the other side of a fence,
yep.
they just can't, you know, um, and this gets, correct me if I'm wrong, but there's a lot of legal leeway if somebody says, I'm going to come back with a gun, or I'm going to, I know where your kids live. I'm going to, that situation. What are your options? Not much, I don't think, but
There's not much. We're supposed to call the police and let the police handle it. We're not allowed to take that into our own hands because if we're not in the immediate, the imminent jeopardy of being hurt, we're not allowed to take that action to hurt someone else. So you say, yeah, I'm gonna kill you. So I can't go across the street from your house and say, I'm gonna take him out so he doesn't have a chance to kill me because that threat wasn't an imminent danger to me. It has to be that immediate for me to do something. Otherwise, your only recourse is to call law enforcement. Law enforcement can go to your house and deal with it.
yeah, if they do, I mean,
Yeah, if they do.
we
Right.
can we're both probably well aware of cases where like, are you kidding me? Um,
Yeah.
but still, you still and I'm just going to point out is like the good people, good people like you and me, more you than me. If somebody makes a threat like that, we are going to go to the police and we're going to say this happened to us. And if nothing happens, the police aren't able to act because of lack of evidence or whatever. And this guy ends up with 30 bullet holes in him. Guess who they're going to be looking at first? That's
Yeah. And so again, there's a lot of it. I mean, we didn't even get into once you defend yourself, you can only defend yourself to the extent that you're still under the threat.
so if he turns
So
and runs away,
we
you
got to
know,
stop. Once he's restrained, once he's knocked out, once he's hurt and he's no longer a threat, I got to stop. And that's, I think, the story and I'll tell it here because listeners don't know it. Years ago when I was in the city attorney's office prosecuting, I had a guy, he was charged with assault. And what happened, there was a bar fight outside of a bar. And during the fight, one guy tripped over the curb, broke his ankle, and was laying on the ground. While he was laying on the ground, the guy that was still standing started kicking him in the ribs. That is when the police officer showed up. So the only thing the police officer saw was the guy on the ground and the guy standing there kicking him in the ribs like 3 times. That the police officer saw 3 kicks and got there and stopped him. Now, this was the real brilliance of the guy doing the kicking. When the police told him to stop, he said, I had to get my licks in. And the police, the police officer wrote that down. So here I'm at, and it was a bench trial. So I only have a judge. I don't have a jury on this one, but I'm prosecuting. And you got to remember, prosecutors want wins in the column. It's not always justice, even though we like to say that. Prosecutors want wins in the column. So that's my job, to get a win in the column. Now, I didn't have much witnesses. I had the guy that was hurt. I had the guy that was being prosecuted for assault. I had the police officer and his report. The way the guy described it is the guy that got the broken ankle, he started the fight. He may have. I'll give, he may have started the fight. And it may have been self-defense until the guy went down with a broken ankle. And so,
That's right.
yep. So my summation of the case was anything that happened before those 3 kicks that the police officer witnessed is irrelevant to what he's being charged with. Those 3 kicks were assault because the person was not a threat at that time. And that's he was found guilty of.
Okay,
Now, even though it could have been self-defense at the beginning, those 3 kicks were going too far. They were not self-defense because he was no longer the threat.
so this might be a complicated situation, but what about ground and pound? I mean, you see, martial arts sports where basically they're on top of them and they are raining down blows to get them, points some of the time, but also to make them basically unable to keep fighting. How much of a legal morass is that?
Like, everything would be looked at the totality of the circumstances for each individual case. You would have to articulate why you continued, and there is a little bit of leeway in that blind rage. But if you were to keep pounding him and you killed him, you could be looking at the manslaughter charges because that was excessive. So you got to be able to halt and not go too far. And sometimes that line is difficult to discern.
Yeah, because you got adrenaline to, you're scared, adrenaline.
Yep.
So and again, you were talking about juries. They've not experienced this. They are in a nice air-conditioned room, heated, trying to make a decision of what happened in the heat of the moment. So yeah, but
Because I'm asked this in active shooter classes all the time. When I'm teaching active shooter classes, you take the gun away from the bad guy and your friends are restraining him. Can you shoot him? Okay. If you're holding his gun, now he breaks loose of the people holding him down and he starts drawing that second weapon. You could be justified in defending yourself and others because he's a threat again. Your friends are holding him down, you have his gun, and a coworker comes in and says, that son of a bitch killed Mary. Mary was your best friend. He killed Mary. Boom, boom, boom. No, that's going to get you arrested. So again, is there a threat? And it has to be a threat that could hurt you or kill you immediately, an imminent threat for you to be justified to act on it.
okay, that's a lot to digest. I'm going to end this here. We're probably going to come back after the verdict comes in on the Daniel Penny case. And again, you've had experience with being a prosecutor. I think your insight will be very great. That will probably be the next episode out. But the basics of self-defense that you went over here, like stop after the threat is gone, things like that. These are things that I don't think a lot of martial arts know about it. So I really appreciate this.
Certainly. Thanks for having me on, Don.
Thanks. Take care. Okay.